Good evening, ladies and gentlemen, and welcome to the second in a series of three 2020 Hamlyn Trust lectures to be delivered by Eleanor Sharpston, the fourth UK Advocate General to the Court of Justice of the EU, the CJEU. Nominally, this is the Belfast lecture, but in reality, it is again to be delivered, as was the first in these exceptional times, from Luxembourg. So may I pick up where Sir David Edwards left off last Thursday and again invite you to board the magic carpet and ride from the College of Advocates in Edinburgh to the School of Law at Queen's University Belfast. I'm Brian Doherty, a solicitor, and I am in the chair for tonight's event. About myself, I've had a career briefly in private sector, but mainly in public service, providing legal advice on EU law to the devolved government of Northern Ireland. I have also had a happy and long parallel academic connection here, teaching at the law school and at the Institute for Professional Legal Studies. And I'm a board member of the Irish Centre for European Law, which is based at Trinity College in Dublin, but maintains an active interest and presence in the other jurisdiction on this island. I'm here with the law school's Professor Gordon Anthony at my side. He is the Hamlyn Trust's Queen's University trustee. So I welcome you on behalf of Queen's and on behalf of the Trust. We are in the moot room of the Tower Block, which houses the marvellous new law school here. So thank you to Queen's University for hosting us. We would not be here without the generosity of the enigmatic Emma Hamlyn. We may not know much about her life in Victorian times, but by her will, despite tussling with her solicitors about the terms, but with the assistance of the Chancery Court, the Hamlyn Trust was created, and it has given us a wonderful tradition of stimulating lectures. As Professor Conor Gearty in a recent article described it, an academic series of immeasurable value. For the record, our speaker is part of a set of illustrious speakers who came from the CJEU to provide the Hamlyn Trust with lectures over the years. In 1977, Lord Mackenzie Stewart spoke on the European communities and the rule of law. Sir Gordon Slynn spoke on introducing a European legal order, and in 2006, Sir Francis Jacobs spoke on the sovereignty of law, the European way. And so to our speaker this evening. For the many returnees to this second of three lectures, I feel I shouldn't repeat the comprehensive biographical, may I say, detail provided by Sir David Edwards on Thursday. But for those joining this evening for the first time, I'll provide a catch-up version. Eleanor has a strong international flavour to her life. She may be settled in Luxembourg now, but she grew up in France, Brazil, Switzerland, and Austria. She has multilingual skills and has had a multidisciplinary education, from the Musical Conservatory in Vienna to King's College, Cambridge, reading economics, languages, and law. On settling on a legal career, she has mixed private practice with over 20 years at the bar from the 1980s, with also public service as a referendaire to Advocate General and subsequently Judge Sir Gordon Slynn from 1987 to 1990. Eleanor has a broad academic experience and academic recognition. To pick the latter, she's Honorary Fellow of Corpus Christi College, Oxford, Honorary Bencher at King's Inn, Dublin, Honorary Fellow of the British Academy. She holds honorary doctorates from Glasgow, Nottingham, Trent, Stockholm, and Edinburgh, and is a visiting professor at the Riga Graduate School of Law, Latvia. But of course, she's perhaps most widely known for her work as Advocate General at the CJEU from January 2006 to September 2020, delivering some 340 opinions over that time on constitutional, substantive, and procedural issues. Eleanor can number herself among a small but select line of eminent UK lawyers who have held the office of Advocate General at the CJEU, which also includes Jean-Pierre Warner, Sir Gordon Slynn, and Sir Francis Jacobs. In addition to all these endeavours, she also has a series of serious sports and other interests. I'm going to mention just one, sailing. The last memory of Eleanor in Northern Ireland is less focused on the impeccably here without notes, and when we change the subject matter of her talk on the day, but rather is a memory of Eleanor the next day, sailing, seriously heeled over in a classic Scottish-designed one-tonner yacht, dodging the drumlins in Strangford Lough in a stiff wind in her element, enthusiastic, committed, ebullient, up for the challenge, as indeed she has shown herself to be in tackling the first lecture in the 2020 lecture series subject, The Great Experiment, Constructing a European Union under the Rule of Law from a Group of Diverse Sovereign States. In her first Hamlyn lecture, Competing Claims to Eminence and the Lessons of Prehistory, our speaker traced the historical development of different legal systems within Europe and showed how and why the Europe of nation states had, by the early 20th century, become a patchwork quilt of different legal systems. Then she took us through the cataclysmic events, the two world wars, that, as she put it, deeply scarred the first half of the 20th century, emphasizing the scale of the devastation and the physical and moral damage that they had inflicted. Against that background, she reminded us of the Winston Churchill Zurich speech, the Schuman Declaration, and the preamble to and the objectives of the European Coal and Steel Community Treaty, the ECSC Treaty. She concluded by looking at the original EEC Treaty, inviting us, as she put it, to try to imagine this treaty as it was in 1957, freshly typed, freshly signed, without knowing how it could subsequently be shaped by the efforts of enterprising litigators and the decisions of the court. Here, she said, is the toolkit for a new start. In the past, law has been allied to power, be that power military, economic, or political. Now, on the contrary, the rather elaborate and ambitious law that the founding fathers had written had been put in place not to reflect power, but to create something new out of weakness, out of nothing. The great experiment was about to begin. And thus, the title to tonight's lecture, A New Start, a New Model, a Unique Challenge. And finally, before I hand over to Eleanor, I'll just say that as I did before, that you can, if you like, pose questions during the course of the lecture online here on Zoom. And insofar as we can, we'll take a number of those questions after the lecture. So, Eleanor, without further ado, the floor is yours.
Ron, thank you very much indeed for that very kind introduction. May I say I'm extremely sorry not to be able to be back with you physically in Belfast as I had hoped and planned and intended. I have the happiest memories of the sailing together that you just mentioned, and it's a great pity that I can't look forward to similar time on the loch on this occasion. I should perhaps add that if my Irish grandmother had not been late in catching that splendid product of the Belfast shipyards, Holland and Wolff, you would probably have been spared having me as the 2020 Hamlyn lecturer. She was, by the way, very worried to have wasted the ticket that her then employers had paid for. Speaking now and looking back, may I say I'm so pleased that she was, as usual, late. Now then, a case about the customs duty due on a consignment of urea formaldehyde imported by a customs agent into the Netherlands from the Federal Republic of Germany lacks, I am tolerably certain, the sex appeal for law students or practitioners engendered by a decomposing snail floating lazily out of a bottle of ginger beer onto a couple of scoops of vanilla ice cream. Nevertheless, Van Gent en Loos, to give it its proper pronunciation rather than calling it Van Gent, Van Gent en Loos transformed the early landscape of the EEC law and set the scene for much that has followed, at least as comprehensively as the judgment of their Lordships' House in Donoghue and Stevenson transformed our understanding of foreseeability and negligence in the United Kingdom. The facts are fairly easy to state. On the 1st of January 1958, the date on which the EEC Treaty entered into force, the rate of duty payable on urea formaldehyde was 3%. Following a customs reclassification, the applicable rate became 8%. Could the customs agent, Van Gent, rely directly on the standstill clause in what was then Article 12 EEC so as to pay only the lower rate of duty? 3 member states, Belgium, Federal Republic of Germany, and the Netherlands, so that's half the initial membership of the club, argued that Article 12 EEC only bound the member states in international law. It did not create rights on which individuals might rely before the national courts. Customs agent Van Gent and the EC Commission espoused the opposite, bolder, revolutionary view that an individual person or trader could rely on the standstill clause in Article 12 EEC as legal justification for refusing to pay the higher rate of duty. At the end of an immensely careful and painstaking opinion, Advocate General Römer proposed that the court should hold that Article 12 only contains an obligation on the part of the member states. Had the court followed the advice of its Advocate General, the course of EEC and EC and EU law would have been utterly different. The EEC treaty would have joined the ranks of international treaties that sovereign states sign up to and then comply with more or less, as realpolitik determines. And the customs agent, Van Gent en Loos, would have had to pay duty on 8% on that consignment of urea formaldehyde. The court in its judgment first set out its view of the task before it and explained how it intended to go about it. This has subsequently been dubbed in EU jargon the teleological approach. And then in a purple passage that has justly resonated down the decades, the court held as follows. The conclusion to be drawn from this is that the community constitutes a new order of international law, for the benefit of which the states have limited their sovereign rights, albeit within limited fields, and the subject of which comprise not only member states, but also their nationals. Independently of the legislation of member states, community law therefore not only imposes obligations on individuals, but is also intended to confer upon them rights which become part of their legal heritage. These rights arise not only where they are expressly granted by the treaty, but also by reason of obligations which the treaty imposes in a clearly defined way upon individuals as well as upon the member states and upon the institutions of the community. The court went on to conclude that, according to the spirit, the general scheme, and the wording of the treaty, Article 12 must be interpreted as producing direct effects and creating individual rights which national courts must protect. Since Article 12 contains a clear standstill clause on customs duties, it followed that that provision was violated by a customs reclassification of products that resulted in an increase in the applicable rate of customs duty. It's hard to overstate the importance of Van Gent en Loos. Without it, primacy and supremacy and direct effect would not have found their way into the EU and the EEC legal order. The European project had worked at all, it would only have been in a muted form. It would not have spread its wings and taken off. As it was, the way was clear for the court to identify other treaty provisions, for example, those governing free movement of goods and workers, freedom of establishment, and freedom to provide services, and the core rules regulating fair competition. And to say that because the wording of those articles was clear, precise, and unconditional, individuals could rely directly upon them before national courts to enforce the rights that they contained, if necessary, in the teeth of conflicting national rules. Now, I pause to observe that from the two succeeding decades, we also derive most of our basic understanding of the rules of interpretation of EU law. Principles which are stated broadly are interpreted broadly. Now, you might think that that is a statement of the blindingly obvious, but it took a while and much deliberate reiteration before the point got home. Exceptions to broadly stated principles are interpreted restrictively. Otherwise, the exception would risk undermining the principle, thus turning the world upside down. National courts are meant to try to do their best via the principle of interprétation conforme, loosely translated as loyal interpretation, to construe national law implementing an EU obligation in a way that is in line with the purpose and objective of the EU measure. The court also decided that after the period prescribed for the implementation of a directive has expired, provisions of that directive that are clear, precise, and unconditional may be relied upon directly by an individual vertically as against the state, or an emanation of the state, but not horizontally as against a private individual. And as early as 1976, in Reva and then Comet, the court established the basic principles of its remedies case law, namely that remedies for breaches of rights conferred by EU law are a matter for the national legal system, subject to the twin principles of equivalence and effectiveness. In a sense, though, deciding that various different treaty articles, which are clear, precise, and unconditional, would all be directly effective was the easy bit. Once you have decided in Van Gentenloos the issue of principle, that treaty provisions are going to be capable of conferring rights on individuals, then wherever the words of a given treaty article are clear, precise, and unconditional, the conclusion will always be the same. That provision will be directly effective. As the treaty draftsmen themselves recognized, however, the rules in the treaty on their own were not going to be sufficient over time to take the European project forward. It was going to be necessary, of course, with the approval of the member states, to put in place further detailed rules so that the broad principles in the treaty could be fleshed out and become fully effective in practice. The story of the completion of the internal market, a big success story of the European project, provides a striking illustration. Initially, progress was swift. Thus, the common customs tariff was established 18 months ahead of the 12-year programme set out in the treaty. Following Van Gent, actual tariffs between member states faded away. But in the succeeding years, progress stalled as the economic environment turned sour. The 1973 oil crisis played, of course, a major part in this. The infant European project appeared to be afflicted with a debilitating disease, eurosclerosis. From the middle of the 1970s and into the 1980s, academic debates and analytical papers sought to identify its causes, whilst the European economy languished, suffering persistent low economic growth, 13 years of stagnation or virtual standstill and high unemployment. The Albert Ball report of 1983 introduced the concept of the cost of non-Europe. As the authors explained, the expression non-Europe was intended to convey the low level of cooperation and the weakness of common policies. They suggested, for example, that the absence of a genuine common market for public orders and for research and development, and all the other obstacles to trade, are equivalent to a fiscal surcharge, which would certainly represent approximately 1 week's work per year, on average, for every family in Europe. Now, this is where I should like to introduce an unlikely hero of EU single market law. A decent, perhaps not very prominent, conservative UK politician called Lord Cockfield. I tell the story as it was related to me during my years in Brussels by close insiders at the European Commission. In 1984, the then UK Prime Minister, Margaret Thatcher, nominated Lord Cockfield to be the British member of the Commission in Brussels, and she was sure that he would be a safe and reliable pair of hands. He had, after all, never stepped out of line during his UK political career. So, Lord Cockfield arrived at the Commission's headquarters in the Berlaymont building, Place Robert Schuman, and was ushered into his splendid new office. On the desk, respectfully placed there for his perusal, was a copy of the EEC Treaty. Since he had been assigned the internal market, tax law and customs portfolio, the relevant sections of the treaty dealing with those competencies had been flagged for his attention. He read them and, a little puzzled, pressed the buzzer for his chef de cabinet to come in for a chat. Well, as far as I can see, most of this should already be finished business. So, what am I meant to be doing? An embarrassed cough. Well, Commissioner, actually it's not quite as straightforward as that. There are still some non-tariff barriers in place in certain, maybe in all, member states. The internal market isn't actually finished business at all. Well then, we should get out a white paper about it, hey? Blank looks. White papers were not at that time a known part of the Brussels legislative landscape. Lord Cockfield explained about that useful UK civil service tool, and in due course on 14th of June 1985, the Commission issued its first ever white paper, COM 85-310 final, completing the internal market. That paper identified the need to remove physical barriers, technical barriers, and fiscal barriers, and it set out in an annex a timetable for completing the internal market by 1992. A little coyly, it listed some 300 individual measures that needed to be adopted in order to effect it. The European Council endorsed Lord Cockfield's white paper in June 1985 and set the end of 1992 as the deadline for the completion of the internal market. To understand why that was such a challenge, notwithstanding its obvious economic attractions, we need to step inside the legislative machinery of the European project. And I shall allow myself to quote Otto von Bismarck, first in German and then in my English translation. Gesetze sind wie Würste. Man sollte besser nicht dabei sein, wenn sie gemacht werden. Laws are like sausages. It's best not to be present whilst they are being made. Let me take as an illustration the rules on, let's say, the fire retardant qualities of fabrics and stuffing used to make toy stuffed lions. No, this is not a figment of my fertile imagination. These are covered by the Toy Safety Directive, and the cover page of the explanatory guidance document bears a picture of lots of fetching little stuffed lions. The treaty rule, what is now Article 34 TFEU on free movement of goods, is that, quotes, all measures having equivalent effect to quantitative restrictions on imports are prohibited. The toy lions fabrics rules would fall within the formula measures having equivalent effect to quantitative restrictions, MEEs in the Euro jargon. However, then there is a treaty derogation, Article 36 TFEU, which says that prohibitions or restrictions justified on grounds of, inter alia, the protection of health and life of humans are not precluded, provided that they do not constitute a means of arbitrary discrimination or a disguised restriction on trade between member states. There is also the Cassis de Dijon case law, which makes room for proportionate national measures applied indistinctly to domestic and imported products that are, inter alia, there for consumer protection, likewise to derogate from that broad treaty principle. Unless we come up with some common standards, there's a risk that each member state will say that its toy lions fabrics rules are there for reasons of consumer safety and to protect public health. They are, of course, proportionate in their impact and naturally do not discriminate against imported toy lions. The fact that there are 3 thriving domestic companies with 1,200 jobs between them manufacturing toy lions to that state's own particular standards is pure coincidence. Putting such cynicism firmly to one side, we shall need, first, to remember both the technical diversity of national legal systems, as I sketched for you in my first lecture, and the choices made by national legislators when setting standards. National rules, where these exist, perhaps they will not exist in all member states, will have been drafted so as to fit into the national legal system of which they form part. The safety standard that they incorporate is not some abstract value. It will have been decided upon as a trade-off between safety and cost. Greater safety, unfortunately, usually also connotes more expensive. Now, suppose we want to make sure that toy lions, whichever member state they're manufactured in, can be sold freely anywhere in the territory of the European Union. How do we go about it? If we're going to have European standards enshrined in European technical rules, there will need to be meetings of technical experts, discussion, compromise. The common rules will need to be drafted in a way that can then be applied irrespective of the legal system within which they will be operating. Probably somewhere on the edges of the process, there will be some lobbying going on by existing vested interests on the producer side of the equation, who would, no doubt, prefer the new rules to be pretty much the same as whatever is the status quo within which they're already operating. For their part, the consumer protection groups will both highlight the dangers of setting common standards too low and insist that the minimum rules cannot be used as an excuse for making the toy lions so expensive that only the rich can afford them. Or let's take the rules on being allowed to set up business in another member state and exercise your profession there, freedom of establishment. It's all very well in theory, but we don't regard what you covered in your professional training back home as adequate to allow you to practice here in our member state. Of course, our primary concern is consumer protection, you understand. The fact that our restrictions also conveniently prevent you from competing with your fellow professionals here and perhaps taking the bread out of the mouths of our local boys is again pure coincidence. Remember the rules governing medieval guilds that I mentioned in my first lecture? So, with that target of completing the internal market before us, let's take a closer look at the tools, the different legal instruments that the treaty draftsman provided for achieving that objectives. These are regulations, directives, decisions, recommendations, and opinions. Often the treaty itself specifies which instrument should be used if member states want to make secondary legislation in a given area of EU law. Thus, for example, Article 52 TFEU, the former Article 57 EEC, gives the EU legislator the varies to issue directives on mutual recognition of qualifications in order to make it easier for persons to take up and pursue activities as self-employed persons. Whereas Article 46 TFEU, the former Article 49 EEC, authorises the EU legislator to issue directives or make regulations setting out the measures required to bring about freedom of movement for workers. So there, two different types of legal instrument are available. Each tool in that toolkit has its own associated strengths and weaknesses. So let's take a look at them. I begin with directives. As you've heard, my example toy yarn fabrics rules comes into this category. The treaty tells us that a directive shall be binding as to the result to be achieved upon each member state to which it is addressed, but shall leave to the national authorities the choice of form and method. So directives look like the ideal flexible tool for dealing with formulating uniform standards or conveying specific individual rights that then need to be transposed into each individual different national legal system. In many respects, they are indeed an excellent and valuable tool, but they are not problem-free. Intuitively, it's easy to understand that the more people there are around the table, here in the sense of the more member states there are that need to be involved in the discussion, the more complex those discussions are likely to be. Getting 6 member states with broadly similar legal systems to agree a text is probably a simpler proposition than getting agreement from 28, now 27 member states. Then there are spats about legal base. To the uninitiated, I suspect the 99% plus, who are normal lawyers or citizens, not EU aficionados, these seem particularly esoteric, akin to the medieval theologians' disputations about how many angels can dance upon the head of a pin. But the legal base is important. The legal base determines the procedure. Depending on the procedure, the measure may be adopted by qualified majority vote of member states, QMV, or it may require unanimity, thus giving any individual member state the possibility of blocking something that it doesn't like, or at least at a lesser level of holding its partners to ransom until it has traded its agreement to that measure for the other's acquiescence in some other measure that it particularly espouses. The Working Time Directive case provides a neat illustration. Under a Conservative government at the time, the United Kingdom was implacably opposed to the adoption of the socialist measure represented by the Working Time Directive. It brought proceedings against the Council, challenging the adoption of that directive on the basis of what was then Article 118A EC, which deals with health and safety at work, a treaty base that provided for qualified majority voting. The UK argued that the proper basis for such a measure was either Article 100 EC or Article 235 EC. Since both those legislative bases require unanimity, either would have permitted the UK to block the directive's passage and deal it its quietus. Unhappily for the United Kingdom's arguments, the very first studies showing the link between overlong working hours and accidents at work were studies in the United Kingdom of munitions workers during the First World War. Studies motivated not by socialism, but by a desire to ensure that the war effort was more effective. The United Kingdom lost all the essential parts of that action for annulment. I observe swiftly in parentheses that there is also a rich and important inter-institutional case law about choice of legal base and hence choice of legislative procedure. This is also neither trivial nor esoteric because inter-institutional balance is delicate and highly relevant to the legitimacy of the European project. Much of this case law is in fact a series of turf wars between the European Parliament and the Council. Those who routinely accuse the EU of having a democratic deficit should perhaps pay more attention to how successful the European Parliament has been ever since the seminal judgment in Les Verts in expanding its influence and its right to be involved more fully in the legislative process. Then there is obviously the issue of whether what a member state has done is in fact a correct and faithful transposition of what was required by the directive. At one stage, discussions with policymakers and civil servants in the United Kingdom often included references to gold plating, going beyond what the directive requires. Now, often there is an article in the directive itself that makes it clear that a member state is free to do just that, provided that in so doing it doesn't break other rules of EU law. More often, the issue is not gold plating, it's whether a member state has under-transposed the directive. That issue can arise because the Commission brings infringement proceedings, but it can also readily arise from litigation between individuals and the state, or indeed between two private parties, which calls into question the adequacy of the transposition of Directive X into that member state's national law. This can in turn raise the question of what precisely the directive did lay down as binding. Thus, in Beck 2, the issue was whether a key element of working time, the entitlement to annual leave under Article 7 of the Working Time Directive, was specified definitively by the agreed common EU rules, or whether it could be nuanced and limited by national rules. Article 7.1 states, I quote, "Member states shall take the measures necessary to ensure that every worker is entitled to paid annual leave of at least 4 weeks, in accordance with the conditions for entitlement to and granting of such leave laid down by national law and or practice." Did that mean that the United Kingdom could, under national law, limit such entitlement to workers who had already spent a qualifying period of 13 weeks with their employer? Fortunately for Beck 2's members, who work in an industry where typical contracts do not last as long as 13 weeks, and who therefore regularly found themselves entitled to no paid annual leave at all, the answer was that the entitlement to leave can be prorated, but every worker does indeed mean every worker. Finally, this is not exhaustive, does the member state's implementation of a given directive actually permit an individual to rely effectively upon the rights that the directive is meant to confer? Let me offer an example of a judgment dealing with that question. The Pfeiffer case concerned the application to emergency medics working for the German Red Cross of both Directive 89391 EEC, which is about measures to improve the health and safety of workers at work, and the Working Time Directive. Having concluded that the relevant national legislation was not compatible with the requirements as to maximum weekly working time laid down in the Working Time Directive, the court turned to the question of remedies. Article 6.2, the remedies article in the directive, would have been directly effective against the German state, but the medic's employer was a private body, the German Red Cross. It took the court 14 paragraphs of rather tortuous reading and reasoning to conclude that the national court must consider the whole body of rules of national law and interpret them so far as possible in the light of the wording and purpose of the directive, in order to achieve an outcome consistent with the objective pursued by the directive. Thus, the national court had to do whatever lay within its jurisdiction to ensure that the maximum period of weekly working time was not exceeded. Let me move on to regulations, which we are told shall have general application. Thus, a regulation shall be binding in its entirety and directly applicable in all member states. Indeed, a member state is not allowed to implement a regulation. Here, the idea is to come up with a single, agreed, detailed common text that will, without further ado, take effect within each member state. Naturally, there will be issues about reaching agreement about precisely what goes into the text. Sometimes there are bizarre omissions. For example, a maritime transport regulation that fails to specify whether it is or is not intended to cover seagoing tugs, tugs that you can see in any harbour in any member state. But once we have our common text, our agreed uniform standard, surely that's the end of the difficulties. Well, not quite. As with directives, the agreed uniform rules will also, because this is EU law, be equally valid in all of the 24 official languages of the European Union. Even though the texts will receive what is delicately termed linguistic toilettage before being promulgated, mistakes and inconsistencies do creep through. When that happens, sooner or later the problem will end up before the court, which will then have to straighten out the mess. In doing so, it has necessarily to apply a teleological approach. You cannot make your authoritative interpretation turn upon the placement of a comma in such circumstances. I'll give you an example of such a problem. Tegelgard and Flöstrupgard concerned the reduction to be applied to the direct support granted to some farmers who had failed to respect obligations in other EU legislation that they were required to comply with as a condition of receiving that funding. The French text of the relevant council regulation said the opposite to the English text, and a comparison of the different language versions revealed that the odd man out was indeed the French text. The Commission had apparently nevertheless taken the French text as the basis for its subsequent detailed implementing regulation, to the great detriment of the farmers in question. The court solved the conundrum in a way that was just, but that was certainly not arrived at by a literal application of the Commission's preferred version of the texts. Also, just a little further twist, some regulations, for example, anti-dumping regulations or regulations freezing the funds of named individuals suspected of involvement in terrorist activities, are really a bundle of individual decisions. So they have in justice to be challengeable by the individual persons or companies affected. That takes me on to decisions. Decisions affect and bind their addressee and sometimes, of course, also third parties. There is not usually a problem here about linguistic diversity. Whatever language the decision was originally drafted in, probably these days English, albeit probably not by a native English speaker, it will be authentic only in the language in which it was communicated to its addressee. But of course, there are real issues with an abundant case law to match as to what is the appropriate degree of judicial review of such decisions. To what extent should an EU court scrutinise the choices made by the EU executive? How wide is the latter's margin of administrative discretion? And which national legal system or systems are we drawing on in order to lay down the principles of judicial review in EU administrative law? There are likewise important serious issues, again the subject of extensive case law, as to fundamental rights, and in particular the rights of the defence, their scope and extent, and whether in any particular case they were properly respected. Whilst recommendations and opinions are soft law and have no binding force, their importance as interpretative tools should not be underestimated. After that detailed excursus into the legislative toolkit, let me return to my main narrative. On with the project. Others have written in detail about the single market, the adoption of the Single European Act in 1986, which, crucially, introduced qualified majority voting in the Council to speed up the legislative process for single market measures. The Ticini Report, 1988, which estimated that the likely gain to the EEC from implementing the measures proposed by Lord Cockfield might be as much as an extra 4.5% of GDP. However, although the single market was meant to be completed by 1992 and was therefore formally launched on the 1st of January 1993, completing the single market remains a work in progress, as subsequent studies by the European Parliament on mapping the cost of non-Europe have made clear. 1992 was also the year of the Maastricht Treaty, which has reiteratively been likened to a Grecian temple, an overarching superstructure, the balanced upon three pillars. Central pillar is what I shall call mainstream EEC law, that is, supranational law, adorned with all the trappings bestowed upon it by the court's case law to date: direct effect, effet utile, purposive interpretation, broad principles, restrictively interpreted derogations, etc., etc. Two flanking pillars, justice and home affairs, JHA, and foreign and security policy, CFSP, were very different beasties. They were intergovernmental, not supranational, and that had important legal consequences. For a start, the member states deliberately excluded the jurisdiction of the court from those two areas, save if the member states perhaps were to decide to negotiate a convention on some JHA topic and expressly provided therein for the Court of Justice to have jurisdiction over that convention. The member states were also careful to specify that although the main legislative instrument created for the JHA pillar, the framework decision, might bear more than a passing resemblance to a directive, it was not, repeat, not going to have direct effect, and might perhaps be forgiven for drawing the conclusion that the member states were less than keen at the prospect of the court being creative or teleological in those two flanking areas. Then we have the Treaty of Amsterdam. This is the stage at which we start to get material moving from the flanking pillars into the central pillar. And the Treaty of Amsterdam, 1999, introduced the idea of an area of freedom, security, the AFSJ. That concept came into being not as the result of some devilish federalist plot, but as the consequence of the successful single market project. You see, removing all border checks and controls is praiseworthy, indeed essential, in order to create a single, frictionless geographical space in which to reap the full benefits of the single market. It streamlines the movement of goods. It's excellent news for honest EU citizens wishing to exercise and enjoy their free movement rights. Unfortunately, it is also marvellous news for money launderers, people smugglers, drug traffickers, organised criminals of every shade and hue. You do not need to be a Euro-federalist to see that some kind of concerted action to deal with the problems that creates is going to be required. Sovereign states can and do have a very legitimate interest in putting common measures in place. The consequent creation of the AFSJ, whilst essential, has introduced EU norms into parts of law, immigration law and asylum, police and judicial cooperation, criminal law, even family law, that are much more sensitive and closer to cherished concepts of the state's imperium than laying down uniform standards for widgets. For that reason, this is also quintessentially an area where member states come to meetings in Brussels to discuss draft measures, carrying briefcases stuffed with their own particular red lines. In consequence, the legislative texts that emerge are often strangely bland, sometimes, dare I say, a little unfocused. Key definitions may be missing, or may exist only in skeletal form, with blurred edges. It is sometimes almost painfully obvious that the reason is that compromise and excision were necessary in order to get any text adopted. When that happens, however, we're looking at a grand chamber case 5 years down the line. Inevitably, it will be for the court, first the Advocate General and then the judges, to select a single meaning from the 2 or 3 or 5 or 6 that have been suggested to it by the intervening member states, each of whom will be espousing the meaning that it was pushing in the earlier negotiations. Deliberate ambiguity will have helped to secure agreement and to allow the new measure to be promulgated. But once the text is litigated, all bets are off. A litigated text, when ruled upon by a Supreme Court, can only have one authoritative meaning. I shall be saying more about the court, the EU institution in which I spent the last 14 and a half years of my professional life, in my final lecture. Let me just briefly complete the chronological narrative. A convention on the future of the European Union was convened in December 2001 with a deeply ambitious aim to produce a constitution for Europe. But that proved a bridge too far. The draft treaty establishing a constitution for Europe was adopted by the Council on 18th June 2004. It was signed in Rome. It was approved by the European Parliament by the Mendes de Vigo Leinen report. However, it was then turned down in referendums, first by France on the 29th of May 2005, and then by the Netherlands on the 1st of June 2005. It was quietly abandoned. Finally, in 2009, came the Treaty of Lisbon. Some saw in it the constitution entering via the back door, merely minus its most obvious federalist symbols, like the official EU flag and the anthem, the Ode to Joy. In truth, it was a rather more modest measure. It was, however, notable for elevating the Charter of Fundamental Rights to the status of primary law, and it incorporated a commitment, as yet unfulfilled, for the EU to accede to the ECHR. And meanwhile, over the years, the European Union has become a much larger club. Institutional machinery designed for 6 founding states has been tweaked, but not fundamentally reformed. There are now 27 different national legal systems within the European Union, until recently 28. There were 24 different languages instead of the original 4. In strict legal theory, all those languages are equally authentic and therefore equally important when it comes to fixing on the correct interpretation of the text, even though we all know deep in our hearts that the chances that the draftsman was focusing on the version in Lithuanian are really rather small. By now, you're perhaps wondering whether this European project is still worth all the hassle. I want in the final part of this lecture to offer you two reasons why, in my unshaken view, the answer is and can only be an emphatic yes. Both reasons are geopolitical rather than purely legal or economic. The first is the seismic shift caused by the disintegration of the Soviet Union and its empire of satellite states. Which landmark in the revolutions of 1989 you highlight is a matter of personal choice. I was a rather younger lawyer working as a referendaire at the Court of Justice in Luxembourg at the time. Luxembourg is multilingual and multicultural with a big immigrant community, so it's easy to get your news in French, German, Luxembourgish, Portuguese, and more. I remember switching between the various TV channels available to me and watching, with tears in my eyes and a fierce, incredulous joy in my heart, footage of Trabants, the only car generally available in East Germany, driving out through Checkpoint Charlie, and jubilant East Berliners tearing, hammering, clawing at the accursed wall. There were the discussions between Solidarność and the Polish government, the public reappearance of Alexander Dubček, the hero of the Prague Spring, before reform in Czechoslovakia was crushed by the Soviet invasion of 1968. And there was the delighted shock when, at 7 p.m. on the 23rd of August 1989, over 2 million inhabitants of the Baltic states joined hands to form a human chain from Tallinn in Estonia through Riga in Latvia, Vilnius in Lithuania. The fall of communism was an utterly extraordinary geopolitical moment that altered the post-war map of Europe. Joining the European Union was a badge of democracy regained for the Baltic states and the Central and Eastern European states, just as it had been 20 years before for Greece after the Colonels, Spain after Franco, Portugal after Salazar. Integrating those states into the European project was a geopolitical imperative. Indeed, the United Kingdom played a significant role in pushing for mass admission to the club, for not requiring new applicants to form an orderly queue in order to be admitted gradually, one by one. Whether its interest in doing so was disinterested, or whether it hoped thereby to dilute the European project by making it wider but not deeper, is here immaterial. My second reason could not be more apposite, since I am virtually, albeit not sadly, physically, in Northern Ireland for the second of these Hamlyn lectures. And my jumping off point is a 1970s agricultural case, well known to our chairman, Pigs Marketing Board against Redmond. On its substance, the court's judgment in that case explored the murkier depths of the Movement of Pigs Regulations Northern Ireland 1972, the bacon pig marketing scheme applicable in Northern Ireland in the late 1970s, and the monopolistic conduct of the Pigs Marketing Board. Note that the Pigs Marketing Board had explained that the Movement of Pigs Regulations became necessary because terrorism in Northern Ireland made other measures for supporting the scheme impracticable. However, that case, wisely referred to the Court of Justice by the resident magistrate, County Armagh, also showed the economic consequences of the border between Northern Ireland and the Republic, whither the 75 pigs in the lorry stopped by the police at Maytone near Market Hill, County Armagh, may well have been headed. Indeed, the resident magistrate had raised a further special question with regard to the restrictions on transport of pigs resulting from the application of the Movement of Pigs regulation. He asked whether such restrictions might possibly be justified by reason of the control facilities which they offer with regard to large-scale smuggling, which apparently takes place on the frontier between Northern Ireland and the Republic of Ireland. There were very good economic reasons why that smuggling was happening. The Pigs Marketing Board eagerly emphasised the connection existing between this aspect of the pigs marketing scheme and the suppression of smuggling. The court was unimpressed, and it very firmly explained that such abuses, if not abolished by the removal of their monetary cause, can only be dealt with by means compatible with the normal functioning of the common market, and that considerations affecting the repression of fraud cannot therefore be relied upon to justify the scheme. Here is the double reminder of the importance for Ireland of the story that is unfolding. The reasoning behind the movement of pigs regulations, the terrorism in Northern Ireland, and the permeability of that twisting 310-mile land frontier between the north and the south, the Irish border. The Belfast Agreements, signed on Good Friday, 10th of April 1998, and hence usually known as the Good Friday Agreements or the GFA, were based on the fact that both the United Kingdom and the Republic of Ireland were EU member states. That made it possible to be creative and to fudge the issue of the Irish border. Because within the European Union single market, a land frontier is no big deal. There are no checkpoints, no procedures to verify customs documents and examine the contents of cars and lorries, no constraints on free movement of goods and persons across that border. The GFA solved the conundrum. Unionists, loyalists could be content. After all, legally the border is still there, and Northern Ireland is indubitably part of the United Kingdom of Great Britain and Northern Ireland. Republicans, nationalists could be content. After all, in practical terms, the border is invisible and therefore non-existent, and daily life can be lived crossing the border without even noticing it. The GFA dealt with issues of sovereignty, decommissioning of weapons and demilitarization, justice and policing, civil and cultural rights. It put in place a constitutional settlement built on power sharing between the two communities. On the 22nd of May 1998, the people of Ireland approved the GFA in two separate referendums. In Northern Ireland, the vote was 71.1% in favour of the GFA, with the campaign slogan, "Vote yes, it's the way ahead," and 28.9% against. In the Republic of Ireland, it was 94.39% in favour and 5.61% against. The outcome of those referendums has been rather less publicised in Westminster in recent years than the 52-48% split in the UK only, Great Britain only, Brexit referendum held on the 23rd of June 2016. The visionary, statesmanlike act that was the Good Friday Agreements largely brought to an end the ghastly period of civil unrest and bloodshed known euphemistically as the Troubles. Its overwhelming popular endorsement by the people of Ireland north and south of the Irish border does permit me, I feel, to put down a gentle marker here about the undesirability of unpicking, in the name of political ideology, a democratically endorsed solution that has saved lives and brought peace and prosperity. These two illustrations show that the link between the European project and peace and stability in Europe is not merely the historical link that I brought out in my first lecture. It is not limited to a snapshot of the moment in time that was the aftermath of the Second World War. That link was relevant then, but it also remains relevant now. So much for the start of the story, my first lecture, and for the narrative of how the European project evolved over the first 50 decades of its existence, today's contribution. Between now and the final lecture, I shall be polishing my crystal ball because I shall be summarizing the recent past and against that background, cautiously trying to look around the corner into the future at the challenges that the project now faces, if it is not merely to survive, but to prosper. Thank you very much.
Eleanor, thank you very much for that talk. Really a breathtaking tour of both the depth and the breadth of European law, helping us to understand that EU law is much more than a technical, legal, market-oriented system, as well as the unique challenges it has internally and the unique challenges which it has to face externally. Very much obliged to you for your preparation. It looks so easy, but you can't put a talk like that together without a lot of hard work and trouble. So we're very grateful to you for that. I'm delighted to say, as I indicated earlier, that we would be happy to put questions to you if you don't mind. And there are some which have come in, after which I will ask Professor Gordon Anthony to close the proceedings for us. So I have a question here in respect of the following. Would the single market have been achieved more quickly or effectively if there had been simpler lawmaking procedures? Or would member states have blocked any moves that might have limited their own autonomy?
That's a very sensible question, if I may say. And I think the answer is that a treaty which had been as bold as that and which had made it easy to put measures through by a simple majority, for example, from the beginning, would never have been signed and agreed. It was only by the time we got to the Single European Act in 1986 that it became possible, and it was very clearly only for single market measures and certain things dealing with free movement of persons, dealing with taxation, were expressly kept still to be done by unanimity. So, I mean, yes, it would have, yes, it would if you had an easier legislative process, but I think the easier legislative process would never have been agreed. And you would still have had the issues that I was trying to bring out about diversity of legal systems, about having to have whatever is agreed actually working within legal systems which are increasingly very different from each other in terms of how technically they do law.
I have another question, which is what approach should the Court of Justice of the European Union take to incomplete, ambiguous, or ineffective legislation? Should it take a purposive approach and risk being more European than the EU member states?
On one view, the court was more European in Van Gent and Loos. Remember that 3 of the member states were arguing that the treaty they just signed only imposed obligations in international law. And they were perhaps a little disconcerted to find that it did more than that, because they had limited their sovereign rights, albeit in limited fields. I think the basic issue is the following. These questions about the interpretation, and I'm taking the example of a measure in the area of freedom, security, and justice, because the courts had a lot of those measures recently to interpret, and very frequently there are gaps, there are blandnesses, there are non-sharp definitions in such measures. Those measures tend to be referred to the court for interpretation from national courts. And it is one of the mantras of the system that the Court of Justice is there to help the national court, that it's a system of cooperation between the national judge and the EU judge. The EU judge isn't deciding the case, but he is helping his brother, the national judge, who is in fact sitting as an EU judge. He's applying EU law in the member state. The Court of Justice is helping the national judge to solve the problem before the national court. And very often, in a sense, whatever the court does, it's going to make a call. It's going to make a call as to how to make a piece of legislation which is, if you like, technically a little imperfect, a little incomplete, how to make that legislation work. And that is why the court will, sometimes to the distress of people trained in the common law tradition, the court will crawl all over the recitals. It will then find that there are recitals which say different things because everyone wanted that aspect of the story to be in the preamble. But at the end of the day, the court is going to have to come up with a single meaning for the text. And if you look over time, you tend to find that if you look at the whole picture, sometimes the member states aren't happy. Sometimes the lawyers acting for individual citizens who feel that EU laws should go further aren't happy. Sometimes the institutions aren't happy. I'm a little tempted to conclude that if nobody is happy all of the time, but some people are happy some of the time, probably the court is calling it about right, generally overall, in terms of what it's doing. Now, naturally, that leaves scope for disagreement on any individual case as to whether you think that the court went too far, just about right, or not far enough.
Eleanor, for your answer. May I indulge one more question? We've taken up quite a lot of time, both on your part and for the audience who've listened in this evening. This is a crystal ball question, really. Do you see the EU moving to ever closer union, despite the misgivings of some member states? Or put another way, where might you see the EU in another 25 years, let's say, to pick a period? Here we're not hearing you, just when we'd love to.
I'm sorry, I have been having technical problems at this end, and thank you for alerting me to that. I can only conclude that my dogs were breathing on the computer because I swear I wasn't touching it. To try to answer your question, first of all, I deeply hope, because I like living in a peaceful, stable Europe, I deeply hope that the EU is still there, and not only just about there, but actually thriving and flourishing in 20 years' time. I think that the EU will, in fact, be dealing with a lot of things with the consent of member states, who are, after all, the masters of the treaty. And I think the EU will be dealing with those things because there are many problems that are transfrontier and that can best be dealt with by the EU formulating and taking common action. It's very difficult to conceive of how, for example, you can deal with environmental issues and climate change by each member state paddling its own canoe. And so I think that the words ever closer union among the peoples of Europe have, in a sense, always been construed or maybe even misconstrued as meaning political union. And I'm not sure they were meant to mean just political union. I read the word union as being a much broader word. I read it as encompassing everything from economic to cultural to social, the exchange of young people between member states, the fact that people regard it as normal to have girlfriends and boyfriends who, you know, whom they met when they were on an Erasmus year abroad as students, or when they went on a package holiday to somewhere else, and then at a local bar they started chatting somebody up. You know, there is a level of exchange which is more encouraging than if you look at the diaries of the British soldiers who went off to fight in the First World War, and you realize that for most of them it was utterly strange to go outside the UK. But they went off to Flanders to fight for their country, and sadly all too many of them rest in Flanders fields. So I think that the future involves an ever closer union, but I'm not sure that the word union should be read as a political union. I think it's union in the sense that we live our common European lives, and that actually that is the essence of what the project is about.
Okay, good evening, ladies and gentlemen. I have the very simple and very pleasant task of bringing this excellent event to a close and saying some words by way of thanks. First of all, I want to thank our speaker, Eleanor Sharpston QC. It was simply brilliant, Eleanor. The first lecture was brilliant, this lecture was brilliant, and I know the third lecture will be brilliant, and thank you very, very much indeed for the time and effort you've made for us this evening. Thank you. I would also like to thank, secondly, Brian Doherty, who served as our chair. He's been very calm and reassuring. I use those words in a very deliberate sense because trying to organise a lecture online has engendered a sense of panic, and Brian brought in a degree of calm to the process, and I thank Brian for his time and interest, and of course his long-standing affiliation with the School of Law. Thirdly, the School of Law itself, I should thank the head of school, Professor Robin Hickey, for lending the facilities to the Hamlyn lecture this evening. The Queen's is one of the trustees, and I'm the representative, and Professor Hickey appointed me to the position, so I would thank him. And I would also thank in particular Richard Somerville, who is the IT guru in the School of Law, Queen's. Without Richard's expertise and, I have to say, patience, extreme patience, we would have been rather lost this evening. So thank you to Richard, and also to Declan Coyle, who brought his organisational expertise and brilliance to the event as well. So thank you, Richard and Declan. And finally, a word of thanks to Cambridge University Press. You'll know the Cambridge University Press have been publishing the Hamlyn lectures for the past 15 years or so. So thank you to Cambridge University Press and to Fionnuala O'Sullivan, who I know was in attendance this evening. So thank you to everybody for attending this evening, and can encourage you, if you haven't already done so, to register for the third lecture in a few weeks' time. Thank you very much indeed.